Vivekananda College of Law, Bangalore. For a brief stint, he was on deputation with Mysore University, where he started, or rather, he was a founder director of Mysore University School of Law, one of the premier legal institutes. As principal of Vivekananda Law College, Professor Kempe Gowda started the 3-year LLB course in 1983-84 and the BA LLB 5-year course in 1986, a year in which the Bar Council had flagged off that 5-year LLB course, and BCom LLB integrated course also. So on behalf of UGC's right, MG University, on behalf of Department of Lifelong Learning and Extension, Mahatma Gandhi University, and on behalf of all the esteemed participants, we have nearly 427 participants for this online certificate course. And on behalf of all of them, I'm warmly welcome you, Professor Kempe Gowda, sir. Now, and for the formal welcome, I just invite Adona Maria James, first semester LLM student of the School of Indian Leader, MG University, Kottayam. Adona, please.
Thank you, ma'am. Good evening. Greetings to everyone. Thank you for joining today. My name is Adona Maria James, and I'm a postgraduate student in School of Indian Legal Thought, Department of Law, Mahatma Gandhi University. It's a moment of extreme pleasure to introduce the resource person of today, one of the most esteemed personalities, Professor Dr. K.B Kempe Gowda, Principal, Vivekananda College of Law, Bangalore. Professor Dr. K.B Kempe Gowda started his teaching career in the year 1990 and joined as a lecturer of law in the year 1995. He has obtained PhD degree on the topic, the legal regime of the Right to Information Act 2005, a critical study from Mysore University. He has published a number of research papers, more than 9 research articles. He is presently the Academic Council of Syndicate member of Karnataka State Law University, member of Academic Council, JSS Law College, Mysore, and a former Academic Council member of Bangalore University. He has delivered innumerable lectures as a resource person. He has participated in more than 120 national and international seminars and has coordinated various legal training camps and legal awareness and literacy programs across the state of Karnataka from the year 2000 to 2012. Today, he has accepted our invitation and has joined us to enlighten us on the topic right to information and governance. It is my honor and privilege to welcome you, sir, to this session. With great pleasure, I welcome Professor Dr. K.B Kempe Gowda, sir, to today's session. Welcome, sir. We are truly delighted with your presence.
Thank you. Thanks for your warm welcome. And at the outset, let me thank my friend, an academic leader, good administrator, Professor Bismi Gopal Krishna Madam, for having given me this opportunity to interact with you all on a very important topic, that is the right to information and good governance. Let me directly go to the topic. Yesterday, I was hearing Professor C.S. Patil's lecture on the same platform, wherein he made a mention, jovially comparing an Indian dog and Pakistani dog, where Pakistan dog, it had everything except freedom to bark. Taken it as a clue, let me develop today's lecture. The synopsis briefly is like this. The concept of right to know, it's a different dimensions, That right to know as a divine right, as a natural right, as a political right, as an economic right, as a social right, and it is everything. And its importance in democracy. Democracy in general and India in particular. Friends, let us try to understand the relationship between the good governance and the concept of right to know. There are some of the rights which we call them as inviolable rights, natural rights which cannot be transferred, basic rights. Such rights are necessary for a human being to develop. And also, as a responsible citizen in a state, these human rights are considered as necessary for controlling the resources which are essentials to meet the basic needs of the human beings. And it even includes the right to good environment and right to citizens, right of the citizens to receive information. This is the observation made by Dr. Jane Boruwalia in his introduction to the great commentary on the Right to Information Act. He has identified the development of human rights right from Magna Carta, then the French Declaration, after Magna Carta, the United States Declaration of Independence, and then the development taken place in international arena with the passing and adopting the UDHR in 1948. But these are all the recent developments. But actually, these type of natural rights are developed and considered as inviolable and an inseparable part of a human being. How is it? Not all the rights are enumerated, but they are recognized. They are acknowledged. What Blackstone says, the common law is nothing but recognition of the principles which are already in existence. The same thing applicable even to human rights also. That's why I told you these rights are inviolable, which are natural, among whom the right to know, the concept of right to know, is also one of the important right. Let me tell you how some of the rights have been developed. Let me tell you a story from Panchatantra for easy understanding of development of these human rights in Indian scenario. One story goes like this. A sage, a sannyasi, he was about to move in a dense forest. When he was made an attempt to go in that way, people advised him not to go and told him that don't go there, there is a venomous snake that is so cruel. Don't go there. It has killed many people. If you go there, definitely you will not survive. Then this person thought of meeting that snake, which was so poisonous, venomous snake, and he went there. He went, then that snake came in front of him. Then he had a conversation with that, and he advised the snake that God has created every human being, and he has only the person who can take away that life. No one can kill anybody. No one can interfere in the affairs of another. Then he took promise from that snake, hereinafter not to bite anybody, not to kill anybody. That snake accepted, and it has agreed, it has promised him, and it didn't indulging in such activities. Later, after passing of 6 months to 1 year, the same person, the sage, he happened to move in that place. There was a drastic change there. In that forest, there was a wonderful road being built. Bridges are constructed. People are moving fearlessly. There was a loss of forest property, trees and other things. Then there was movement and all the commercial activities have been taken place. Then this person worried about what happened to that particular snake. He is in search of it. He went there. He met that snake. He called that snake. That snake came from behind bush, a feeble snake which came and appeared before him. And he asked, what has happened to you? You are so healthy, but now you are so feeble. You are so weak. What has happened to you? There are many injuries on its body, even some grievous injuries. Blood was oozing like anything. Then he asked it, what has happened to you? Then that snake said, for my present condition, you are responsible. I took your advice seriously. Stop biting. And then people started beat me like anything. The people, while passing through this particular road, they used to stone me. And then these are all the injuries caused because of it. Then that sage retarded. I advise you not to bite anybody, not to kill anybody, but I didn't advise you not to raise your hood. The God has blessed every animal as an organ to protect itself, not to kill anybody. There are some animals which are having sharp nails. There are some animals which are having horns to protect it, not to go and not to kill anybody. But these are all the creature of the God to protect itself. Then through that story, they indicate us everyone has the right of private defense. Everyone has the right of self-defense. Likewise, these type of rights have been followed, observed, and recognized by the legal system. Among whom this right to know is one such right. Right to know is one such right. Let me tell you the story, because I know you are all law graduates. Some of you are professionals. Some of you are research scholars and law students pursuing your master degree. You are familiar of this case. It's a famous case decided by an English court. Justice Coke was the presiding officer, fortunately, in that particular case. In that case, the brief facts of the case is this. A professor working in one of the universities in a prestigious college in England. He was working in a university. He made several allegations against the Vice Chancellor. When he made allegations against the Vice Chancellor, that Vice Chancellor exercised his power and removed him from his post, that professor's post. He questioned, he challenged it before the court of law. You see, being an employee, he was not supposed to make any allegations against his superior officers. Then the Vice Chancellor took a decision to dismiss him from service. His dismissal is being questioned before the court of law in England. On behalf of university, there are some best brains have been engaged to defend the action of the Vice Chancellor. They argued vehemently that, my lord, you look at statute book, what it says. The Universities Act. That University Act clearly empowers and indicates that the Vice Chancellor is the chief executive, as well as he is the competent authority. He is the competent authority who can make rules and regulations. He can appoint his own officers. He can frame rules and regulations. He can fix wages, service condition. And also he is the competent person to initiate disciplinary action against any employee of the university, right from a professor at the top down to a class 4 employee. It is his power. He exercised that power that cannot be questioned before any court of law. That was the argument on behalf of the university. Justice Coke asked the council to stop for a while and started narrating a story from Christian mythology. As we all know, according to Christian mythology, God created Adam and Eve, and at the same time, he has created a beautiful apple tree, and he asked them not to eat fruit, but they ate it, and then the God summoned both Adam and Eve. And before going to pronounce his judgment, God, before going to punish them, he gave them an opportunity. God told them specifically, yes, I told you not to eat that fruit, but you ate it. For which, before I am going to pronounce my decision, I give you an opportunity to you people to convince me, why did you violate my dictum? If you could able to convince me, I may go to the extent of exonerate you from all the charges. Otherwise, I will pronounce my judgment. This is sufficient for our purpose. You see, in that story, the God himself gave an opportunity to Adam and Eve. Justice. In this case, Lord Justice, later he became Lord Justice Coke. Justice Coke, in this particular case, questioned the Vice Chancellor like this: do you consider himself you are above the God? Over and above the God? Even God himself gave an opportunity to Adam and Eve. You are a Vice Chancellor of a university. You are bound to follow the principles of natural justice, where he used the term, the principles of natural justice. In this case, he pronounced that it's a right on the part of an accused to receive, to know the charges leveled against him, and also he is entitled to know the charges framed against him, and he has to be provided an opportunity to defend himself. That is called the principles of natural justice. Friends, with this background, let us discuss the concept called right to know. Why human being always curious to know something about others? This is the human tendency to know everything about others than himself. We are curious to know our neighbors, what they do, how they behave, etc., than concentrating on himself. It is the human tendency. That curiosity in him is the first and foremost thing, that inquisitiveness, in other words, we call, that is responsible for trying to know something about the affairs of others. That really responsible for the emergence of concept called right to know. This right to know has emerged as a political right, an economic right, and this right to know becomes a social right, etc. It has taken different form. Let me tell you how does it considered as a political right. We are all in a democracy. We are all in a democracy. We are in democracy. The sovereignty is vested with the people at large. We are supreme, we are sovereign. But we have to accept one important truth, that is the reality is we are Ek Din Ka Sultan. We are Ek Din Ka Sultan means we are Sultan for a day. When you go to a polling booth to exercise your franchise, once you entered and exercise your vote, after having indelible ink on your finger, when you come back, nobody will bother about you, nobody will respect you, nobody will salute you. If you want to remain even an Ek Din Ka Sultan on that particular day also, you have to wait till 6:30 in the evening. People will come, people will beg, people will pursue, take you forcibly to a polling booth. At least you will be a king till the evening. Now, in such circumstances, being a responsible citizen in a country, in a democratic country, I do not want to remain as an Ek Din Ka Sultan, but I want to know and I want to participate in each and every decision-making process of the state. That is called as a political right. Now, this right to know has become a political right, friends. Next, it has become an economic right also, because whose money are you paying? Whose money are you spending? On what scheme you are spending money? In Karnataka, we are having Bhagyas now, Grow Lakshmi, free bus, and etc. Then how much money are you spending and whose money it is? Is it not your responsibility to give answer to the people? Because you are spending my money, then you have to give me account for each and every paisa you have spent. That becomes an economic right. Then even it becomes a social right. How? We always imitate others. Yes, I consider it is, yes, all the, and another chief important source of law is imitation. My professor, Professor C.K. Raja, used to give us this example while discussing sources of law. Imitation is one of the important source of law. That society have this particular practice, why not we? America has this type of legislation, why not we? Even in the legal system also, we try to imitate others. Man is a bundle of imitation. Man is a bundle of imitation. Professor Tade had written one important book on imitation. That book, the first chapter of the book, the title of the first chapter of the book is The Law of Imitation. The first sentence in that book is Man is a Bundle of Imitation. We imitate one or the other, right from combing our hair up to even tying our shoelace, etc. We imitate. Then the chief source of law is imitation. Likewise, this concept called right to know, or having this type of right through recognized legal system in the form of a law, was a demand by the general public that is responsible for these type of transparency legislations we call, like the Right to Information Act. In international era, it is called as the Freedom of Information Regime. In most of the countries, they call it as Freedom of Information Regime, FOI. Friends, with this background, let us understand the development of legal system of Freedom of Information Regime. For the first time, in Sweden in the year 1766, in Sweden, there was a legislation called Freedom of Press, wherein that they recognized the right to know as one of the fundamental right of the citizens. But a systematic legislation has been framed in United States of America. That is in the year 1966. That is, it's called as the Freedom of Information Act 1966. That was the first systematic legislation on freedom of information. That legislation was dealing with, it is a right on the part of each and every citizen to claim it as a matter of right, some information from all federal agencies as well as state agencies. There are some limitations here in that legislation. Such limitations have been omitted. In one of the important legislation passed in the United States of America is the Sunshine Act 1974. This Sunshine Act is developed based on an observation of American Supreme Court, one of the judges in American Supreme Court in one of the important judgment. What he has observed in that particular case was this: sunlight is the best disinfectant. Sunlight is the best disinfectant. That clearly indicates that transparency is the only remedy to contain corruption and to prevent nepotism. Then, taken cue from this, the American Congress passed a legislation called Sunshine Act in 1974, wherein it made even some private agencies also, not even public authorities I am talking, even private agencies are also bound to disclose information which are of having national significance. Let me give you an example. Even though it is a private pharmaceutical company, if it's okay, this clearly indicates that even the private agencies are also made to disclose some information voluntarily which are having national importance. That I will discuss little later. Then, if you go to another important development taken place in England in the year 2000 was Freedom of Information Act 2000, but it came into force fully in the year 2005. Then let us come back to Indian scenario. You all know the attempts made in India by different organizations by different voluntary organizations, civil society organizations. They fought for it, and we got it in the year 2005. First time there was an attempt made by CERC, that is Consumer Education and Research Center, Ahmedabad, wherein Manubhai D. Shah was the founder president. He made an attempt. He prepared a bill that the draft has been circulated, but there was no taker for this. Later, the Press Council of India, in the year 1997, they framed the Freedom of Information Bill. It was circulated. Then it was referred to H.D. Shourie Committee. That committee recommended some amendments to this, and then it was resulted in passing of the Freedom of Information Act 2002. Though it got approved by both the houses of parliament and got the assent by the President of India, it did not see the light of the day because of its own reason. Later, it was passed in UPA 2, which is called as the Right to Information Act 2005. These are all the attempts made here. But we have to remember some of the organizations which are dedicated themselves to see that there must be a systematic legislation for a country like India, that is the Right to Information Act. One such organization is MKSS, that is Mazdoor Kishan Shakti Sangathan. Aruna Roy and her colleagues, they made Jaisalmer district in one of the villages in remote villages in Jaisalmer district of Rajasthan as their home. They started interacting with the people there. They collected information from them. They organized Jan Sunwai, that is public hearing, with the help of village officers, district officials, and requested them to have a public hearing there. And in that public hearing in that particular village, it was, a lady sarpanch was forced to pay 2 lakh rupees on the spot because whatever the grant sanctioned by the government, the state government, to that particular village panchayat was not properly utilized. Even there was a grant, the money sanctioned for the purpose of drainage, but there was no drainage in the village, but it was on the paper. Likewise, all the schemes have not been implemented. Then that village panchayat sarpanch was forced to pay the amount. That was the first experience in India, which resulted in movement taken place in other states also. Then other organizations like the CHRI, Commonwealth Human Rights Initiative, and other organizations are also joined this movement that is resulted in passing of freedom of information by various states in India. This is concerning legal development. But prior to that, before 2005, what was the situation in India? Whether citizens of India enjoyed the freedom of information or right to know or not was the question. For which the answer is, our active judiciary is responsible for conferring the freedom of information on the general public, I mean the citizens of India, through interpreting Article 19(1)(a) of the Constitution. What this Article 19(1)(a) speaks, you all know, the freedom of speech and expression. While interpreting it, our Supreme Court in Romesh Thappa case declared freedom of, and then various other judgments are there. I'm going to take up only few cases, 1 or 2 cases, to impress upon you how this concept called the freedom of information and that provision has been interpreted by the Supreme Court. The famous case is Rajnarayan versus Indira Gandhi case in the year 1975, decided by Allahabad High Court and also by the Supreme Court. You all know that a case where Rajnarayan filed an application before the district collector, requested them to share some information regarding the money spent on the visit of then Prime Minister Mrs. Indira Gandhi to her constituency, that is the Raebareli constituency in UP. Then how many vehicles have been used to give her security, how many government vehicles are used, their logbooks, then how many police people have been deployed to provide her security, and etc., etc. These are all the information sought by him. It was rejected by the district collector, stating that these informations are relating to the safety and security of the none other than the Prime Minister of the country, that is VVIP, and such information cannot be disclosed. When he questioned it before the Allahabad High Court held that whatever the security related informations are there that could be covered, the rest of the information could be disclosed by the district administration. Then they challenged even it before Supreme Court. Supreme Court upheld the decision of Allahabad High Court. That was the first case wherein there was an element of right to know was recognized, and the freedom of information was also being recognized. But specifically in SP Gupta versus Union of India in the year 1982, our Supreme Court declared right to know as a fundamental right. Justice Bhagavati made some observation in this case, and which was the foundation for the interpretation of this provision in other cases, in other future cases. Very important cases. You all know that Tata Yellow Pages case, West Bengal Cricket Association case, and all other cases, and including ADR, that is Association for Democratic Reforms versus Union of India, in that case, where the Supreme Court accepted the argument on behalf of the petitioner in this case that the Election Commission has to collect information about the party one who contested for election. I mean, the candidate one who contested for election in the form of an affidavit, and it has to be published in the official website of the Election Commission. In this case, what they wanted, in fact, the petitioner wanted the every information about an individual, I mean a candidate one who contested for election. Yes, education qualification, his assets and liabilities, and his criminal antecedents. These three are important. Even sometimes my professor used to joking as that even the name of the candidate one who contested also properly known. Take for example, in my constituency, in the Lok Sabha constituency in Karnataka, our film star, the former MP Ambarish, was the minister, a union minister. His name, in fact, Amarnath alias Ambarish. His original name was Amarnath. Okay, anyhow, name is educational qualification, because being a responsible citizen of this country, I want to exercise my vote in favor of an educated. I do not want to exercise my vote in favor of an LTM. That's why I want to know his educational qualification. Then I want to know his assets and liabilities, because in most of the circumstances, in the last election, one candidate declared 30 crore as his asset, and after 5 years he may declare it as 300 crores or something. We want to know what magic he has done. which means we want to know his assets and liabilities, not only of us, even his family members. Then comes his criminal background, because I do not want to exercise my vote in favor of a criminal. Hence, I want to know how many cases are filed against him and is being prosecuted, punished, etc., etc. Such details I want to know. That was the main demand of this petitioner. Then in this case, the court accepted it and held that yes, the election commission has to collect all such information and provide details. Then after that, as you all know, that is the Representation of People's Act has been amended, and wherein there was a provision has been inserted to this particular legislation, wherein it declared that, I mean, the parliamentary inserted a particular provision to limit the judicial review or judicial interference in the election process. Once the election is being declared, it is the power vested with the election commission under Article 324 of the Constitution, and no court can interfere and direct the election commission to conduct election in such a particular manner. But that was also declared as unconstitutional by the Supreme Court, again in ADR case, and that is the history. Then even concerning that VVPAT and other cases, Dr. Subramania Swami's case, wherein this VVPAT was made to introduce in one of the constituencies in Nagaland for the first time, and then it was tested there, and the Supreme Court directed Election Commission of India, after its success, to use it in all other constituencies. These are all the judicial role in guaranteeing the right to know in a legal era. Friends, with this, let me pass on to the Right to Information Act 2005. The very objective of this particular legislation is, as stated in the preamble, is this: to ensure transparency, openness, good governance, to contain corruption. I mean, it is one of the objective of this particular Right to Information Act, but it is not the sole objective. And also to empower citizenry, to participate in the decision-making process of the state. These are all the broader objective we have. And at the same time, our parliamentarians very much aware of the conflicting interest here, because all the information cannot be shared with the general public on demand, but the state must be empowered to keep some information in the interest of what Section 8 Clause 1A and B says. In some circumstances, these are all the restrictions which are, the exemptions provided are similar to Article 19 Clause 2, whatever the restriction on the freedom of speech and expression, more or less the same thing is there here. I mean, in other words, the state can maintain secrecy, and the Official Secrets Act 1923 is still in force. Wherever RTA is not in operation, then this particular the Official Secrets Act 1923 is very much in picture. Friends, that objective clause clearly indicates that it is its intention to empower the citizenry to effectively participate in a democratic state. One of the observations of Justice Bhagavati is this: in democracy, not only providing information or receive information is sufficient. To receive true facts, true real information is also a fundamental right. In some of the cases, our Supreme Court observed that it is an important right. That clearly, let me mention one observation made by James Madison. I quote, "Knowledge will forever govern ignorance, and the people who mean to be their own governors must arm themselves with the power knowledge gives. A popular government without popular information or the means of acquiring it is but a prologue to farce or a tragedy or perhaps both. This clearly indicates the importance of sharing of information. It is the citizens' right to know the facts, the true facts, not only the facts, true facts about the administration of the country, thus one of the pillars of a democratic state. This observation clearly indicates that how important the information for an individual in a democracy. In a Secretary, Ministry of Information and Broadcasting, Government of India versus Cricket Association of Bengal, our Supreme Court has observed that the democracy cannot exist, I quote, the democracy cannot exist unless all citizens have a right to participate in the affairs of the polity of the country. The right to participate in the affairs of the country is meaningless unless the citizens are well informed of all sides of the issues in respect of which they are called upon to express their views. Friends, further, the court observed that one-sided information, disinformation, misinformation, and non-information all equally create an uninformed citizenry, which makes democracy a farce when medium of information is monopolized either by a partition central authority or by private individuals or oligarchy organizations. These are all the observations clearly indicate the importance of the free flow of information in a democracy. The democracy survives on public opinion. The democracy thrives on public opinion. When we say democracy thrives on public opinion, we have to provide information that is true information to the general public to form public opinion, a correct public opinion. A piecemeal information or piecemeal, what you call the leakage of some information which are not true, then it would result in formation of incorrect public opinion. Then in such circumstances, it is a responsibility of the state to provide full information to the general public. Then keeping that in mind, the Right to Information Act provides certain mechanism to seek information from the public authorities. There lies my topic, that is governance, that is the good governance. Broadly, we can say there are some important ingredients of good governance are openness, transparency, accountability, and participation. Openness, which means every transaction of the state has to be taken place in an open space, which means it should not be within which cannot be a prerogative of the few to take decision. It should be discussed, and the consulted opinion of the general public have to be taken place. Then the transparency in all dealings, which are necessary, not only necessary, it is inevitable for the survival of, for the good administration. Then third one, we have to provide an opportunity to participate each and every citizen in the decision-making process, which means the democracy requires participation. And accountability is another important thing. These have to be satisfied. That is the importance of the objective clause of this Right to Information Act 2005. And also we have to balance the conflicting interest. Here in the Right to Information regime, friends, there are two extreme ends. One is the demand by the demand side, then another one is the supply side. Then this supply side and demand side, always they are pull apart, and then we have to make a balance between these two. Then there is a fine balance between these two in the Right to Information Act 2005. Now let us discuss some of the definition clause, wherein section 2 clause E deals with the competent authority. That competent authority, that is the definition wherein the President of India and then the governors of the respective state the Chief Justice of India and the Chief Justice of respective high courts, and then administrators appointed by the President of India and the Chairman of Rajya Sabha, speakers of Lok Sabha and the state legislative assemblies, etc. They are the competent authority, which means what we have the Right to Information Act 2005, that is under which the Union of India framed certain rules, that is the Right to Information rules, and then the Karnataka State Right to Information rules or Kerala State Right to Information rules. That is, the authorities, the competent authority only can make the rules. Whereas in case of the respective high courts, the Chief Justice of the respective high courts are the competent authority to frame their own rules. There are cases before decided by the Central Information Commission regarding the fees prescribed by various high courts. The application fee in one of the high courts it was 500 rupees as application fee, but in the general rule it is only 10 rupees is the application fee. But whereas in some of the high courts it was 500 rupees, it was 100 rupees, and then in most of the circumstances the Central Information Commission held that no, you have to apply the general rule and you prescribe the uniform fee for it. These are all the conflicting interest. And then for our purpose, the very important provision is section 2H, which deals with public authority. The definition clearly indicates that all constitutional authorities are public authorities, or statutory authorities are public authorities, or local self-government, local authorities are the public authority. And then the very important thing that even though it's a private body which receives substantial financial assistance from the state, that becomes a public authority, and an NGO which receives financial assistance from the state, that is also a public authority. Now, section 2H, wherein there are some important case laws decided by the Supreme Court, particularly from your state, that is the state of Kerala. One case is Talapuram Housing Cooperative Society's case. It is a leading case. In that case, there was a question discussed here, debated and argued before the court of law was this: what is the meaning of the term substantive, substantial financial assistance means what? For which the Supreme Court is of the opinion that if the transaction of that particular organization, in case of a, the fund received from the state government or the central government is more than 50%, then that authority becomes a public authority. Which means here, that is, if the total transaction, if the total transaction of that organization is 100 crore, if 50 crore or more is being provided by the state, then that authority, even though it is a private entity, that becomes a public authority. It is bound to provide information. Then the second important aspect here decided by the court is that that particular assistance, not necessarily through a financial assistance, even it could be in any form. It could be even in any form, in kind. It could be. Then the third important thing is that the functional character of that particular organization has to be taken into consideration in some circumstances, not in all circumstances. These three important aspects have to be taken into consideration. This case has its own ramification, and it is influencing the decision of various state information commission as well as the Central Information Commission decision. Let me give you an example what has happened in state of Karnataka. One of my student, he filed an RTA application before Karnataka State Cricket Association, KSCA. That is the Karnataka State Cricket Association at that time were famous cricket, this was the Karnataka State Cricket Association, which is registered under the Karnataka Societies Registration Act, which was a private organization. He filed an application before them that, have you appointed the public information officer under section 5? the first question. Second one is, have you disclosed information voluntarily? You're bound to disclose under section 41B. This is the information. Then third one is, what is the criteria to give membership in your Karnataka State Cricket Association club? These are all the information he sought, for which they gave only one line answer that ours is a society registered. Reply that the reply was this: ours is a society registered under Societies Registration Act. Ours is not a public authority. We are not receiving any financial assistance from the state. That was the one line reply given by him. But he argued before, in a second appeal, he argued before the Karnataka State Information Commission that by the time CAG report came to his rescue, that CAG report estimated that the BBMP, that is Bruhat Bangalore Mahanagara Palike, as incurring loss of rupees 800 crores so far for granting that important piece of land in the heart of the city. Per square feet, it was 80 paise per square feet per year is the rent. Then in the heart of the city, that is 80 paise per square feet, that clearly indicates it is a substantial, substantive assistance provided by the state authorities to KSCA. And the Karnataka State Information Commissioner, Dr. Sajjananavar, he declared the KSCA as the public authority, and even it went before the High Court. Then High Court declared it as a public authority. And then in most of the other cases, in Bangalore particularly, the Indranagar Ladies Club, Karnataka State Golf Club, in Mysore Race Course, and etc., etc. These are all the authorities which receive the substantive assistance from the state, was declared as public authority under section 2H. Even they are also bound to disclose information thanks to these decisions. Anyhow, section 2H plays an important role, but I'm not going to discuss section 2F and 2J, which deals with information and right to information, because which clearly indicates that all the records, emails, facsimile, and then record, everything are considered as the information. Then very important thing for our discussion, for our academic discussion, is section 3 and the relationship between section 3 and section 6. Initially, there was a conflict regarding who can apply for information and who can seek information, because section 3 clearly indicates that it shall be the right of every citizen of the country, subject to the provisions of this act. Subject to the provision of this act, every citizen shall have the right to information, is the word used. The word citizen in section 3 is important, and also in section 6, a person, one who desires to seek information, one who wants to seek information, he has to make an application in writing under section 6. The word person and section 3, citizen, the word citizen in the section 3 was in conflict. In fact, in some of the authorities, they used to demand, you have to prove first, before seeking information, you have to prove that you are a citizen of the country. Then in the Central Information Commission, in most of the cases, want the public authorities to reject application for want of, proof of this citizenship is a fraud on this particular legislation. You are not supposed to reject on that flimsy ground, because you can resort to section 8. Wherever some information are exempted, then you can resort to section 8 and not to have this flimsy ground to reject application under section 3. Next comes section 4 is crux of this particular legislation. What it says, voluntary disclosure or suo motu disclosure clause we call. Section 41A and 41B, which says that section 41A, within 120 days from the date of enactment of this legislation, you have to, catalog all the information, you have to digitalize all the information, and anybody can seek information, anybody can, by click of mouse, you can collect information from that. This made mandatory on the part of the public authorities to prepare themselves to provide information to general public. Under section 41B, there are 17 items mentioned. These 17 items are clear indicative of These are all the information voluntarily to be disclosed by the public authority to have citizens to have minimum resort to Section 6. What is this? You have to give information, full information about your own organization. What is your organization here? If your organization is a revenue department, take for example in the revenue department, or yours is a transport department, what is the genesis particularly? How this organization has been established? Was it established under a particular statute or not, and etc., etc. All such details have to be provided. And what is the budget allocated to your department? Then how you spend that particular money, and then the organizational setup of that particular organization, like who is the boss. Take for example, in case of a district collector, he is the district collector and his subordinates, etc., etc. Right from him, and then what is his pay scale and other details. Everything has to be voluntarily disclosed. In case if it is a department which gives subsidy or giving scholarship to the student by the social welfare department or any other department, they have to give the details of the beneficiaries and the norms prescribed for distribution of it and etc. These information have to be voluntarily disclosed. In case if it is a small office like a taluka, gram panchayat, where in the notice board of that particular gram panchayat such information could be disclosed. Whereas in case of a public authority like the revenue department, transport department and others, they can voluntarily disclose that information in their website to avoid RTA applications. This is the intention of it. Then another important obligation of the public authority is to appoint as many as public information officers and assistant public information officers are possible and needed in that particular organization. Then it is a duty on the part of the public authority to appoint them. In case of a Mafuzal area, they can appoint the assistant public information officer. Then assistant public information, after collecting that information, you can send it to the public information officer within 5 days. Then within 30 days of receiving such application, the public information officer has to provide information. Otherwise, if he rejects, he has to give reasons under Section 8. These are all the things. But very important for our purpose here is Section 4, 5+4 and 5+5. This clearly indicates that the deemed public information officer concept has been incorporated into this. If you are designated as a public information officer, take for example in a college, principal is the public information officer. Then the information with the office superintendent of that particular organization. Then office superintendent has to assist the principal and he has to provide information to the principal to give information to the applicant, disclose information to the applicant. But in case if that office superintendent is not cooperating with this public information officer, then that office superintendent, it is the duty on the part of him to cooperate with him and to provide him information, failing which he is considered as a deemed public information officer. Then whatever the punishment prescribed for non-disclosure of information on public information officer, it also is equally responsible. The other person is also equally responsible, and even whatever the punishment provided under Section 20, that is also could be imposed on the office superintendent. This is the illustration I can give you for better understanding. Then Section 6, which clearly indicates that any person who wants to make seek information, he has to give an application in writing, but there is no particular format is being prescribed. And also there is a proviso, in case if that particular person is in need or assistance, then it is the responsibility of the public information to reduce it into writing. Take for example, if an illiterate approaches a public information officer seeking information, then it is the responsibility of the public information to reduce public information officer to reduce it into writing and collect that information. Nowadays, there are many the ICT initiatives have been used by the public authorities to seek that information. The one classic example is Parivartan is an organization founded by and Arvind Kejriwal, and it is effectively used by Nitish Kumar when he was the chief minister for the first time. Presently, he is the chief minister, but it was implemented. That is Jankari system we call. That Jankari system wherein the Parivartan as an organization entered into a memorandum of understanding with them. They established a single window system at capital, that is in Patna. Then any person who wants to file an RTA application, he has to use a dedicated landline, that is BSNL landline. Then an applicant has to pay rupees 10 as per section 6. He has to pay an application fee of rupees 10. Then how can he pay that 10 rupees as application fee? Then that 10 rupee application fees is added to BSNL landline bill. That here it is the win-win situation for everybody. That is, even BSNL will also be involved in it. Even it is helpful for the public authority to receive an application. Then the dedicated trained staff are there in that single window organization. They collect information, they send it to the concerned public authorities. There is no delay in sending of application and receive information from them. This was the finest way found, and it was for the first time they used this ICT initiative effectively to implement the right to information. Such an attempts are made, friends. Then they have to provide information. Then very important provision here is section 6 clause 3, which empowers the public information officer or the public authority to transfer that application from one authority to another public authority. Take for example, if an information is partially available with you, if you are a public information officer, it is partially available with you, and other information partially available with other public information officer in other public authority, can transfer that application to that public authority within prescribed period. Then public authority can provide that information. This is used. Some controversies are there. It is finally settled by the Central Information Commission. What it says that partially, if you have partial information, you disclose that information. The rest of the information you can send it to the concerned authority. There are some disputes in this respect. Section 7 is also says that it is your bounden duty to provide information within 30 days. That is very important. The word used here is, the people are under the impression that the 30 days is the limit prescribed. In fact, it says that as expeditiously as possible, but not later than 30 days. Which means if you provide information even before 30 days, which means within 5 days or within 10 days, you are at liberty to do, but the maximum period you can take is 30 days. In case if the public information officer failed to disclose that information within 30 days, then he cannot levy further fee on the applicant. Take for example, if you want a 1,000-page information from a particular department, then the public information officer can calculate it according to the rules of the respective state or the Union of India. Take for example, in Karnataka, state right to information rules for A3 size paper for Xerox and provide information 3 rupees. For A4 size it is 2 rupees and etc. Then that is called as the further fee to be calculated and inform it to the public, the applicant. Then applicant has to file that info, after payment of that information, the public information officer has to provide that information. In case after 30 days, if failure on the part of the public information officer, that public information officer cannot collect that further fee from the applicant. That is one of the safeguards is being provided here. Next comes section 8, very important, which deals with exemption. Section 81A2, 81J. And I have no time to discuss the each head here, but as I've already made a mention, what Article 19 plus 2 contains almost all is there in 81A and B. Then comes it protects intellectual property rights, which protects copyrights, which protects the commercial secrets, trade secrets, and also fiduciary relationship is one of the ground to reject information, not providing information, and also the hampering the investigation is also, and then privacy at last under section 81J, the personal information. These are all the criteria are there. But let me discuss one case with an illustration. I can impress upon you how complicated a case sometimes, which is not attracting only a single provision under section 81. It also, bundle of other issues involved in it. In one case, it was decided by the Central Information Commission, Information Commissioner Shailesh Gandhi decided this particular case. That is, one person filed an application before the Delhi Development Authority. Before Delhi Development Authority, he requested the sanction plan by the Delhi Development Authority concerning a semi-commercial and semi-residential building. Then the public information officer, he didn't disclose information directly. What he did, he issued a third-party notice under section 11. Section 11 empowers the public information officer, if need be, he can give third-party information. Then he issued third-party notice under section 11. Then that particular person, he has 5 days time to issue that notice. Then the concerned person, if any objections, he can file that objection within 10 days, 10 plus 5, 15 days. Then the public information officer again will get another 30 days to disclose information, which means when section 11 is being, if a public information is resorted to issue notice under section 11, then you will get time till 45 days. Normal, the period is 30 days, but under section 11, it is 45 days. But here in this case, he issued a third-party notice. Then when he issued a third-party notice, that particular person came with several objections. The objections are like this. Number one, my right to privacy is being violated here. It is my building. My, personal information is involved in it. Where do a Tom, Dick, and Harry come to know that where I do, sleep, I cook, I read? These are all, in a house, every details are involved in it. That is the places which are earmarked there. Then why a third party come to know about my personal information? Such information cannot be disclosed. It is protected under section 81J. Then second important aspect is, it is violative of the intellectual property rights of my architect. Take for example, if I build a house, I spend more money on elevation rather than what I use inside, because it is everybody's desire that yes, building has to appear this, differ from others and unique from others. That's why they spend lots of money on elevation of the building. Then that elevation is the intellectual creation of that particular architect that cannot be copied and shared with another person. It is the violative of intellectual property rights of my architect. Hence, it is an objection being raised. Then third important thing is that it is the Delhi Development Authority is having a fiduciary relationship with me. That fiduciary relationship is that I prepare this plan, I submitted it to the concerned authority. That concerned authority has to keep that information. It is a communication, private communication between myself and the public authority. It is like a privileged communication between a doctor and a patient, a client and a lawyer. Then such information cannot be disclosed. Then in this case, after taken into consideration the argument of all the parties, the Information Commissioner agreed with some of the objections raised by the concerned person here, and informed the public information, directed the public information officer to cover up such information which are private in nature, which are having fiduciary relationship, intellectual property rights, commercial secrets, and other things. Such informations can't be disclosed. Then this case is the clear indicative. This case, in other way, it is an illustration which shows that in an application, more than one exemptions are being discussed. And friends, in some of the leading cases, that is Aditya Bandyopadhyaya case and other cases, the Supreme Court discussed something about the fiduciary relationship. Take, for example, it is a fiduciary relationship between a professor and the university. A professor, one who set question paper, a professor, one who evaluated a paper, a person, one who reviewed that a particular paper. You can disclose information regarding the correction of an answer script and etc. But you are not supposed to disclose the name of the evaluator and the reviewer. Such informations are concealed, are covered. We are having, right, take for example, in case of Ramachandra Deshpande's case, it is an important case under section 81J, where our Supreme Court declared that the most of the information of a public servants are nowadays covered under section 81J. Critics criticized that particular judgment, which in fact defeating the purpose, the very purpose of this transparency legislation called the Right to Information Act. Anyhow, friends, let me move to then another important area, that is section 18 and 18, 19, and 20, because we can safely omit that the controversy regarding appointment of information commissioners and other things from section 12 to 17, where in 2019, Parliament amended the RTA Act. Earlier, the RTA Act given fixed period for the information commissioner. That is 5 years from the date of his appointment or 65 years, whichever is earlier. Now, after this amendment, it is as determined by the central government. This is the word they inserted here, which means even for the Central Information Commission as well as the State Information Commission, the period is as prescribed by, the tenure is as prescribed by the Union of India, and also their salary and other emoluments. It is as determined by the Parliament from time to time. A very important thing here is, earlier their status was, take for example, in case of the Chief Information Commissioner at the Central Information Commission, his status is equivalent to the Chief Election Commissioner of India. Then other information commissions enjoyed the status and privileges of other election commissioners. Whereas in case of the state, the Chief Information Commissioner status is equivalent to that of Chief Secretary of the state government. Then other information commissioners' status is equivalent to that of the state election commissioner. And now it is not the thing, it is as determined by the government from time to time. That is the only changes made, but it is still pending. Dr. Anjali Bharadwaj and others, they questioned it before the Supreme Court. And one more case, that is very important case, a Supreme Court advocate, I am going to discuss that particular case little later. Then comes section 18 and 19. That section 18 deals with the complaint, and section 19 deals with appeal, section 20 deals with penalty. What are the major changes here as interpreted by the Supreme Court is, in state of Manipur versus Manipur State Information Commission, the Supreme Court here, restricted the scope of section 18. The critics criticized that our Supreme Court in this particular case restricted the scopes of section 18. What is the gist of the Supreme Court decision is that first one has to resort to section 19, that he has to avail the alternative remedy available under section 19. That is, there is a provision for first appeal, there is a provision for second appeal. That is, first appeal is with the first appellate authority in the same department, second appeal with the State Commission or the Central Information Commission. He has to avail whatever the alternative remedies available under Section 19, then it can result. Madam, okay, rest hold, madam. Okay, sorry. Okay, sorry for disturbance. Okay, am I audible, madam? Okay.
Yes, sir.
Okay, right. This section 18 and 19 and 20, complaint, appeal, and penalty. Now, in that particular judgment, as I already mentioned, the critics criticize that the Supreme Court is limited the scope of section, section 18, but section 18 is even today it is very effective. And then the court can under section 19.8b, section 19.8b, it is nowadays commonly used by the State Information Commission and Central Information Commission. If the applicant proved before the second appellate authority that he was put into irreparable loss for not providing information within 30 days, or in case of emergency situation, that is 24 hours, within 48 hours, a public information officer is bound to disclose information in some circumstances. In such circumstances, yes, the very important thing there is this: in case of serious violation of human rights, then the public authority is bound to disclose information within 48 hours. It is used in most of the circumstances like illegal arrest by the police people, keeping him in custody in a police station. In such circumstances, the people used to file an RTA application to get CCTV footage of that particular police station. In such circumstances, it is because it is the serious violation of a human right, then within 48 hours, the public information officer is bound to disclose that information. Such situations are there. Then let me go to, because I have only 3 minutes of time to conclude my discussion. Then I will take up some of the few questions, because I know that a good number of questions have been posted here. Then what are all the bottlenecks in implementation of this Right to Information Act? There is no doubt the Right to Information Act is one of the important legislation. You can use it for public good. The people like Dr. Anjali Bharadwaj, and then Supreme Court advocate, one person that the famous judge's case, it is forget his name. These are all people, those who use this particular legislation for public. Major bottleneck here is people use it as a grievance redressal mechanism rather than using it for public good. Then the second important thing is that we entrust that responsibility to the public information officers to disclose information, but without providing them proper training, proper facility. If you go to a taluk office, if you go to a village panchayat, you will come to know how your documents are being stored. There is no proper storeroom. There is no proper record room. There is no ICT initiative. There is no computers being provided. They are not properly trained. Then how can they provide information to them? In such these are all the bottlenecks. And another important bottlenecks is legislation is being used by somebody they misuse this particular RTA Act through filing frivolous RTA applications. It is unnecessary burden on the public authority. The public authority can't respond to it properly, and it is resulted in decrease of efficiency of the public authority. Such things happening. There is a truth in it to a certain extent, but that is not only the correct picture, because every legislations are there to use it, and then people used to say that show me any one of the legislation it is not been misused by unscrupulous people. Every legislations are being used as well as misused, but it is a wonderful piece of legislation. We have to use it for the public purpose. With this, yes, I thank Madam for providing me this opportunity to interact with you on this. Madam, if anybody ask any question, I take some of the question to answer. You can post it also, I think. Yes, madam.
So there is one question that is
Yes, madam.
by
Yes, can't hear you, madam.
just a minute, sir. So, is there any regulation regarding the official informations which injure the officials while disclose the information to citizens? If it exists, which provision may be reliable? Sir, I'll read it once more. Is there,
Yes, madam, please.
any regulation regarding official informations which injure the officials while disclose the information to the citizens? If it exists, which provision may be reliable? It's posed by Blessing.
Yeah, not audible, madam, because
maybe Blessing, you can clarify the question, sir, please.
Yes, madam. Yes, Blessing, please.
Sir?
Yes, madam. Yes, madam, please.
Sir, if the official discloses any of the informations regarding the citizens' well-wishes, the information that provides the officials, which leads to injuries to themselves. It's
okay. Yeah. Yes. I think your question, I can take it in this way. If my information is being disclosed to somebody else, then what is the remedy? Correct? If my information disclosed without my consent to a third person, correct?
Yes, sir. Yes, sir.
Yeah. Okay. Yeah. Section 81J comes into picture, which protects right to privacy of an individual. A public information officer is not supposed to disclose all such information. But every exception under section 81A to J, which clearly indicates that in case of public good, the public information officer is authorized to disclose such information.
Okay, sir.
Every provision, in every provision. Take for example, in case of copyright also, and under section 9, in case of section 8, that is the commercial secret, trade secrets, and then fiduciary relationship. In such circumstances also, if the public good demands, the public information officer can disclose that information. There is a protection to the public information officer.
Okay, sir.
Yes.
Okay, sir.
Next.
So there's another query that is, can we seek out the information of the person for which is to be required as an evidence in the court? The RTA Act bars the disclosing of personal information, and if the court provides permission for the same, then the person can also bring suit regarding the breach of his privacy. It's posed by Sanjay Jha.
Yes. Sanjay, it's a good question. Let me tell you with example. Here, a software engineer in Bangalore used RTA Act extensively to prove that he is an innocent. The case was this. His wife filed 498A, a case against him, and other domestic violence and other provisions are also Dowry Prohibition Act provisions and other things. And that person was arrested by the police. He was in central jail in Bangalore without bail for 24 days, and then he came out on bail. He took up RTA as his interest to collect information to prove himself that he is an innocent. What did he do? He filed RTA before the BBMP, Bruhat Bangalore Mahanagara Palike, because his wife alleged that she was staying in one of the PG in Koramangala. That address she gave. He filed an application to BBMP. Whether that particular flat has been used for or permitted to be used for a commercial purpose, number one. Second one, he filed with the electricity department. Have you given connection there, whether it is commercial or domestic? Second thing. Then he filed an RT application before the gas agencies, whether it is a commercial, because in case if it is a PG, it has to be commercial only. Likewise, he filed, and even he filed an RT application before the railway department, because on the day on which he was alleged to hit his wife, he was traveling from Davangere to Bangalore on that day in a Shatabdi. Then he filed that particular application to railway department. He collected information from them about himself, and after collecting that information, he submitted it to the court, and he got acquitted. Justice K.L. Manjunath, while delivering the judgment in acquitting him from all the charges, appreciated him for using RTA for a good cause. Okay. Now, in these circumstances and in other circumstances, in one case, in a leading case, can husband seek information about the bank account and other transactions of his wife? Because the PAN card, bank account, and other things are prohibited. They are not supposed to be disclosed. But whereas in case of husband and wife, a dispute in such circumstances, your question is regarding use it as an evidence. Normally, what we do to collect such information through court, we request the court of law to issue summons to produce document to the concerned authority. That through judicial process, you can receive such information sometime. Then, if you file an RTA, what happens? You collect information. When you collect that information, that information has to be certified by the concerned authority. The public authority put their seal. This certificate, this is the certified copy issued under the Right to Information Act. That seal is there in each and every copy of the RTA information you received. Then that could be used as an evidence before court of law to prove. I hope you are convinced now. Next question, madam. I can't open chat box here, otherwise I would have. Yes.
Are private bodies covered under RTA Act? Are private bodies covered under RTA Act?
Yes. The private bodies, take for example, we are all teachers, we are working in education institution. A private unaided education institution which is not receive any financial assistance from the state is a body which is protected from disclosure of information. Correct? Yes. Likewise, a private organization, your Stri Shakti Sangha, you can have your friends group, one association, one club and of yours which is not receive any financial assistance. In such circumstances, you cannot get that information. But you remember, if you understand RTA properly, no private body escape from it is not disclosure of information. In other words, indirectly you can collect information from everybody. The best example is an housing society. Yeah, an private housing society, which is a registered housing society, which is not received any financial assistance, not in finance or in kind from the state. But it is, they have to submit every year after general body meeting, they report to the concerned public authority. The public authority here is the registrar of housing, registrar of cooperative societies, where you can file an application to registrar of cooperative societies to collect information about that housing society. That what has happened in Talapuram Housing Society's case. Now, if you understand RTI properly, you can collect information from the public authority to which you are bound to disclose information. Take, for example, mine is a private education institution, and I am not receiving any aid from the state. I cannot directly give information to the applicant. But if that if he wants to collect information about my institution, he can file an application to the registrar of Karnataka State Law University. Then Karnataka State Law University registrar is bound to disclose such information because he is the one who is having that information. What Section 5 says is this: every public authority is bound to disclose information if that information is held by the public authority or under the control of the public authority. These two words are there: either held by the public authority or under the control of the public authority. Now, these are all the public organizations. Some of the public organizations, when they file their annual returns to that public authority, then through public authority, you can collect information about that private organization. Then that private organization is not completely exempted from disclosure of information. You cannot directly collect it from them, but you can indirectly collect it from the concerned authority.
So,
yes.
Does the judiciary come under the purview of scope of RTI?
Certainly. Certainly. That is a very important case decided by the Supreme Court. Yes, I can't, recall his name. He is a famous person. He filed an RT application before the to the registrar of the Supreme Court. That RT Subhash Chandra Agrawal case. Okay, Subhash Chandra Agrawal case. He filed an RT application before the Supreme Court. The registry of the Supreme Court is this: please furnish me the copy of the full bench, resolution passed by the judges in the year 1997. Certified copy of that particular resolution. That resolution was this: in 1997, in an informal way, the Chief Justice of India called for a meeting of all the judges. They passed a resolution wherein they have decided all the judges of the Supreme Court have to file their annual returns to the Chief Justice of India. Then all Chief Justices of the High Courts, they have to submit their annual returns, that is, their assets and liability report to the Chief Justice of India. Then all High Court judges have to submit their annual returns to the Chief Justice of the respective High Courts. This was the resolution passed. It was an in-house resolution passed by them. Then Subhash Chandra Agrawal wanted to know the certified copies of the resolution. Then how many judges have filed their annual returns, that is the assets and liability report to the Chief Justice. Then he sought certified copies of such disclosure of information. Now the court said, the public information officer said, no, it was the Chief Justice of India is having that information in his fiduciary capacity that cannot be disclosed. It is a fiduciary relationship means it is by trust they provide information to the Chief Justice of India. The Chief Justice of India is not bound to disclose that information. Then the matter went before the Central Information Commission in the second appeal. The Central Information Commission ruled that in that case, Central Information Commissioner Mishra, he made an observation. My lord, I request your good authority that you are always insist all the public authorities to be a role model in disclosure of information. But now it is your turn. Please, you set a trend in disclosure of information. I request your lordship to disclose your information to the general public, here in this case, and the applicant. Then they filed an appeal before the Delhi High Court. In the Delhi High Court, Justice Ravindra Bhatt wrote judgment against the Supreme Court, which means he directed Supreme Court to disclose that information. And then in that particular case, he quoted one important statement of Edmund Burke in House of Commons in England. There was a proceedings, impeachment proceedings against Lord Mountbatten, perhaps here. He committed excesses in India. He was involved in corrupt practices in India, etc. This was the allegation against him. In that debate, Edmund Burke, a great political scientist, he was the member of House of Commons. He made an observation. I impeach him in the name of God. I impeach him in the name of every citizen of India, every man and woman of India, whose human rights he has trodden under his feet. You see, he mentioned that how the human right is important. Then here, in this case, Justice Ravindra Bhatt quoted that statement and reminded the Supreme Court, in your previous judgments, you watch for transparency in public dealings. Now it is our step, being a part of constitutional body we are. Then we have to follow the rule of law. Then it is our turn to disclose information. Then against which the Supreme Court, Registrar General of the Supreme Court filed an appeal before the division bench of the Delhi High Court. Delhi High Court upheld the decision of Justice Ravindra Bhatt. Again, the matter went before Supreme Court. Very recently, Supreme Court decided that case and approved the observation of Justice Ravindra Bhatt in that case. Even judiciary is also, as and under Article 12, it is a part of the state. It is a state, and here for Section 2H, judiciary is also a public authority. It is the Chief Justice of India. In that case, Justice Ravindra Bhatt mentioned the Chief Justice of India is both public authority under Section 2H as well as competent authority under Section 2E. Yes.
So, there's another question, that is, if right to true information is also a fundamental right, can legal action be taken against media who publish exaggerated news? Will such action be violative of media's right to freedom?
Here, the popular concept we all know, trial by media, correct? Yes, trial by media and other things, for which there is a Press Council of India. There is a procedure prescribed under that particular authority. It is which can look into the complaint filed against a particular media house. They will look into it. They reprimand them sometimes. Sometimes they recommend it to the government to impose serious restriction on that particular media house and etc. It is not covered under RTI. There is a separate way to tackle them. This is the, and I hope you are convinced now. Next.
So the last question in the chat box is, if a student receiving fee reimbursement from state come under the purview of RTI? But the receiving fee reimbursement from state come under the purview of RTI?
No, fee reimbursement means, and I do not know because I cannot understand what is the procedure is there in Kerala, because fee reimbursement here in Karnataka, there is a practice. Social Welfare Department reimburse whatever the fee they have paid to the college. It is the Social Welfare Department's responsibility. Earlier, they used to send it to the college. Now, whatever the fee paid by the student, that is directly going to the account of the student. Now it is the responsibility of the concerned department. But here, concerning the reimbursement and other things, whatever you have paid it to the institution, then there are scheme provided by the state government and the policy adopted by the state government under which you are entitled to get. But to know the reason for not reimbursing, you can resort to RTI. Correct? To know the reason for not reimbursing it, you can resolve to RTA, but you cannot compel authority to use RTA to reimburse it. Yes. That's why I use the term, this cannot be used as a grievance redressal mechanism. It is your grievance, you can address to the concerned authority to get remedy. Yes.
Sir, those were the questions in the chat box, sir.
Yes, ma'am. Yes, I can't open it here, the chat box.
All the questions, I've read out all the questions, sir.
Okay,
I've read
okay.
out all the questions.
Yes, madam.
I don't know whether any other questions are there from the participants. Esteemed participants, do you have any questions, any queries? Yes. So thank you so much, sir, for that very compelling and well-structured lecture. So it is truly captivating, and it was well articulated as usual, sir. So I just, for a formal vote of thanks, I just call upon